Good morning, everyone. The meeting of the Escambia County Board of Adjustment on March 18th, 2026 is hereby called to order with 4 members present. We have a quorum. Can we have the swearing in the staff? Would the clerk please swear the staff members of staff?
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. Members of the board, copies of staff's resumes have previously been provided and remain on file for reference. The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The BOA meeting package for March 18th, 2026 with the Development Services staff findings of facts have previously been provided to the board members. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do we have a motion? Motion by Mr. Patterson. Travis, I'm sorry. Do we have a second?
Second.
Second by Ross. All those in favor of the motion, please raise your right hand. Motion passes. With all members in favor. Do we have a proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of the legal advertisement. Do we have a motion?
Motion.
Motion by Ross. Do we? Second by Greg. All those in favor of the motion, please raise your right hand. Motion passes 4 in favor. Members of the board, you have reviewed the minutes of the Board of Adjustment meeting held on February 18th, 2026. Upon your review of the minutes, are there any additions, deletions, or corrections? Seeing none, the chair will now entertain a motion regarding the minutes of the Board of Adjustment meeting held on February 18th, 2026. Do we have a motion? Motion by Travis. Do we have a second? Second by Greg. All those in favor of the motion, please raise your right hand. Motion passes. If we could have the purpose of the Board of Adjustment and conduct of meeting by Ross.
The Board of Adjustment hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the Board of Adjustment may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development order for site plan and approval are final unless overturned by a court of competent jurisdiction. The county may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if applicant requests the issuance of any such order or permit, and such order and permit is issued, the applicant and not the county shall bear the risk that such decision may be set aside. The development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions, or any aggrieved party as defined by state law, may seek review of such decision by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date that the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may, within 15 days thereafter, apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue Request to Speak form and submit it to the clerk of board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed Request to Speak forms. We must have these forms completed, we must have these completed forms for public record.
All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communication. Ex parte communications are presumed prudential under Florida law and must be disclosed as provided in the Board of County Commission Resolution 96-13. Before a decision by this board on any administrative appeal, variance, or conditional use request, the chair would ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and describe the communication. Our first case is case number CU 2026-06, 1516, 1512, 1800, 1800 and a half, 1716 and 1800 Border Street, a conditional use request to allow a salvage yard. Request by Meredith Bush, agent for TWM Coors, LLC owner. Have there been any ex parte communications regarding this case? I'm seeing none. Any knowledge or information obtained from the site visit or other sources? Seeing none. If any board member intends to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are a party to this item please come to the podium and state your name and address for the record so you can be sworn in by the clerk?
Good morning, members of the board. Meredith Bush, 314 South Balin Street, Suite 108, Pensacola, Florida, 32502. As an attorney, I'm not typically sworn.
Okay, thank you, Ms. Meredith. Were you provided with a copy of the criteria required to obtain a conditional use and a copy of the findings of facts?
Yes, sir.
Okay. You understand that all criteria must be met in order for the board to grant a conditional use?
Yes.
Thank you. Would you like to make a presentation, or would you like to hear from the staff first?
I'm happy to briefly make a presentation. This is a situation where we are in agreement with staff's findings. Staff supports our request. I can run through the criteria. As far as general compatibility, it's an existing salvage yard. It's existed there for decades. It's compatible with the surrounding industrial and other transportation-oriented uses. And you'll see on the photographs, the entire area is industrial in nature. Facilities and services, public facilities and services are available and adequate. On-site circulation, ingress and egress are sufficient. The site is not intending any new construction. This is part of the process to bring it into compliance with the Land Development Code. Because the site has been there for decades, the zoning did not match the use. And so we are currently going through a rezoning process. The Planning Board recently approved or recommended approval of the rezoning. That'll have to go to the Board of County Commissioners. This approval, if granted today, is going to be contingent on that rezoning approval. Nuisances and hazards, the scale, intensity, and operation of the salvage yard have been established over time, and they do not generate unreasonable noise, dust, odors, or hazards. As far as solid waste, material storage and waste handling are operated and managed on-site in a manner consistent with the established use. There will be no new solid waste impacts created. Screening and buffering will be compliant with the Land Development Code. Signs and lighting, no new signage or lighting is proposed. Site characteristics, the size, configuration, and location of the parcels are appropriate for the salvage yard activities as demonstrated by decades of continuous use. There will be no changes to setbacks, height, coverage, or intensity. And then as the use requirements, salvage yards are expressly identified as a conditional use within the HCLI district. and we do meet those criteria. One thing also to note, this is within a CRA district. We've conferred with the CRA department. They have no objections. If you look at the community redevelopment plan for this area, it specifically identifies Border Street as an industrial area, an area to be used for industrial, proposed for industrial, even though recognizing that the, old zoning doesn't match with the industrial use, which again is why we're going through the rezoning process. I'm happy to take any questions. Again, we support staff's findings.
All right, thank you. Any questions for her from the board? I have one question for you before we hear from staff. It's been operated for over a decade, and was it under operation? Were they operating knowing that they needed a salvage yard permit, or have new zoning have that made them have a need for it?
So it's been operating for multiple days. I want to say 20, 30 years, if not greater. If you look at the Google Earth images, I don't know whether or not, the use predates the current zoning. I don't know whether or not the use predates all countywide zoning, because the Google Earth maps, when you look back that far, you can't really see. I mean, they're kind of blurry. So whether or not there were cars and salvage activities back there that long ago such that it predates zoning. However, our position that it is grandfathered, and given that, historically, as far back as anybody can document or remember, these uses have existed. It's simply that the zoning was, when zoning was put in place, it didn't match the existing, what was on the ground.
Okay, thank you. Staff?
Yes, sir. Andrew Holmer, Escambia County Development Services. This is conditional use case 202606. Here we have our location map. The 500-foot radius showing the current zoning has high-density mixed use. As Ms. Bush explained, this is in a rezoning process. The staff was recommending favorably to the conditions. The planning board has recommended approval. Our approval of the rezoning, it's going to the BCC the beginning of next month, and there was no opposition. The future land use for the entire area is mixed use urban. And there we have that community redevelopment area overlay. There, it is within a 20-year travel time contour from an ECUA well. Just by overview, the wellhead protection areas are either 7-year or 20-year. There are very specific use restrictions within the 7-year. Within the 20, it's more of a notification. This is an aerial map of the site, and on this you can see there is quite a mix of uses. There are a few residential uses to the north and west. To the east, you've got the railroad tracks, and then over that, you've got a car crushing operation and what had been a salvage yard on just to the east of that. There's a public hearing sign posted on site. This is looking north along Border Street. This is looking into the site from Border Street. This is facing east. There's a second public hearing sign. It's a large site. Looking east into that site from Border. And this is looking northeast into the site from Border. As to the findings, again, that's a request for conditional use approval to bring this existing salvage yard into compliance with the Land Development Code. And to your question, Mr. Chairman, the original zoning the county had put on site was R5. Possibly for density it was appropriate, but not for existing uses at that time. So this one, this is basically cleaning up that what should have been resolved back in the early 90s. As to the first criteria, this is general compatibility. The proposed use can be compatible with the surrounding area due to the nature of the existing land uses along Border Street and the adjacent area. The pattern is mixed with high-density residential and heavy commercial uses to the west of Border, and primarily intense commercial and light industrial uses to the north and south. Across the railroad to the east is a salvage operation that received conditional use approval in 2008. Criterion B, public facilities and services are available to serve the subject parcel and are currently being utilized by the applicant. Regarding on-site circulation, ingress and egress will be via existing driveway connections to Border Street. D, no new nuisances or hazards are expected with this request, as this is an existing salvage operation seeking to come into code compliance. Solid waste. Solid waste service will be provided as needed by the applicant. F, this is regarding screening and buffering. Screening along Border Street is necessary to meet the CRA requirements for outdoor storage. The adjoining parcels to the north and south are undergoing rezoning to HCLI and won't require buffering. The parcel to the east is an existing salvage yard, and they will not require screening. Criterion G, signs and lighting. Any new proposed lighting will need to be directed onto the site to avoid nuisance conditions. Site characteristics. The site is currently operating as a salvage yard and has proved to be adequate for the use. Specific use requirements. The proposed HCLI zoning does not contain use-specific requirements for a salvage yard beyond this conditional use approval. As to the findings, staff recommends approval of the conditional use as requested, pending BCC approval to rezone to HCLI.
Thank you, sir. Any questions for the staff? I just have one thing to ask. So basically, as you stated, this is cleaning up from something in what it was 2008.
The approval across the railroad tracks was 2008. I've been here a long time. I remember that one well. There was a number of things that this operation has been going through to clean up. There was some right-of-way that needed to be vacated in the area. That was taken care of through the BCC. The rezoning to HCLI is in the process. And this would be that final step, is the conditional use. That would bring it all into full compliance.
Okay. So is it fair to say that part of that cleanup process, it could have been decisions or it was not decisions that the county had made at that time?
I believe there was a code case because the existing use wasn't matching the current zoning. So they're doing a clean sweep here and bringing everything into compliance.
Yeah. Drew's absolutely correct along with Meredith. This basically is clean up. And there was some what we call commercial creeping and all of those things. We're trying to bring everything together, and because this site had never been developed for anything else. Never, because of all the contaminants that's already existed because of this use. So the county, the CI area said, let's get it cold, let's get it correct, and let's make it even better for this type of operation that's definitely in that whole area. So that's why all parties, all the CIA areas, the rezonings, everything, and they're going to possibly need some site plan review process, but everything is in line to bring this site, make it an industrial area for this specific section of the county.
And that's what I was going to touch on as to your question. So we will be going through DRC at least to provide, a current site plan. There may be some additional screening and buffering, but it is part of an overall process to, at least make it look better and meet code.
Right. Yes.
Any more questions from the board? Staff, anything else?
No, sir.
I personally feel that the applicant has operated this yard, for years without requirements and required permits, and continue unpermitted operation cannot constitute, competent substantial evidence of compliance with the land development code. Criteria H, the finding of facts. Can you go back to that, if you would? Sure. The site is currently operating as a salvage yard and has proved to be adequate for the use. Any claim of adequacy is self-created, and there's no verified evidence that use satisfies safety, environmental compatibility, and comprehensive plan requirements. Is that like a real fact? That they're adequate. How do you know if they're not permitted?
So
Let me come on. Okay. Again, in this area, in a type of operation like this, there's gonna be some what we call commercial creeping, and of different things, and possibly because people don't always come to see us when they're doing certain things. After this came to light, because staff really is in support of this fully because it's necessary. After this came to light, the owners, the applicants, the attorney, they said, yes, we want to make it whole. We want to get everything right, get everything in order, lined up so it can be consistent with operations that are ongoing, with some future operations that may have occurred, and with some things that may not have been done appropriately. So they came, had a good extensive meeting, because the area, again, it'll never be residential, never, because of the contaminant that's out there. And this area, so the zoning was not adequate for those type of uses. So, sir, let's get it, everything, and there are some additional parcels that may have been acquired. So the owner want to comply, and staff is in full support. CIA area said that even with the plan, there's a CIA area for this plan, and they said this area should definitely be zone industrial so that it can fit some of those old uses that may not have been done as they should have, but they were occurring. So that's why this is a good way of doing things where the owner can proceed. Let's make it right so we can buy about all of the evidence. And if there's any other things that are necessary for them to do during the site plan review process, we will get those things mentioned, and they got to comply. If not, they're going to do it because they have to. Engineers have already been involved. We have meetings with them. So it's a good move afoot with this to bring everything together and make it whole.
I agree with you. It's good. It's a good thing to make it whole, but I have seen, far too often people not complying, and then years later they want to comply. I know it needs to be made right, and I know we're dealing with stuff that maybe it could have been a business owner or it could have been the county. We're not going to point the blame at nobody this morning. And I don't see any residents, here that's not in agreement of it this morning. But is there a way, if this is approved, and only if the board sees fit, could there be any fines or penalties added onto whatever permit fees they have?
And if I may just address, and I respect your concerns and your questions, we're not conceding that it's been an existing violation, because again, if the use predates the zoning, then there are lawful nonconforming use provisions, there are grandfathering provisions. In an attempt to work with the county, we're doing this process versus going in and arguing against the county's ability to enforce anything at all. Because we do, want to be good citizens. The owner wants to comply with the concerns, address the concerns, go ahead and get it all fully, in line with current code. But the idea or question whether or not for years and years, 30, 40, 50, I don't know how long. I can't give you a date that this started, however long ago. But as far back as we can document using satellite imagery, using all records and evidence, this has existed. So the idea that, anyone has been flagrantly violating the code is something that we would, my position and our position is that's simply not the case. But again, we do recognize current zoning, needs to be HCLI. As Mr. Jones in our report states, even the county's own documents indicate that this area is to be industrial. The redevelopment plan itself specifically calls out Border Street as an industrial area for future industrial growth. Criterion H specifically, it calls for the size, shape, location, and topography of the site. The size of the site is adequate. Actually, the 5 or 6 parcels listed as part of this process have been combined into one parcel. Again, the roadways have been vacated. So this has been, a lengthy and expensive process for the owner, willing again to fully comply. So the size is adequate. The shape is adequate. The lot's not configured in such a way that it would not allow for this operation. The location is adequate, again, because it's in an industrial area, it's surrounded by industrial uses, and it's been identified, I don't know when the CRA was put into place, but quite a few years ago, as an industrial, area. And then the topography, it's not, hills or valley. I mean, it's, flat piece of land. So looking specifically at that criteria, even notwithstanding the fact that it's been proven as adequate because it's been there forever and, or for as far back as we can document, the other issues, the use, setbacks, intensity, bulk, height, open space, all of those are, documented by the actual facts. And so to answer your question, I believe criterion H has been met through the facts. And again, we're trying to be good partners with the county rather than fight some lengthy legal argument about whether or not they can make us do this. We're voluntarily coming in and saying, hey, let us comply. If you want whatever steps we need to take, we want to do it because we want to continue operation in the appropriate area. Obviously, if it were surrounded by, subdivisions or low-density residential, then, you would have a much stronger argument or basis to question. But again, this is, designed and designated by the county within mixed-use urban. So the comprehensive plan, we're in compliance with the comprehensive plan. It allows for HCLI. And so, given that your position is constrained by your, directed to look at competent and substantial evidence, the county staff, all of their testimony as experts and all of their documents fully supports every criteria, and the decision has to be based on the criteria. We are aware that someone filed a code enforcement complaint, absolutely, and that kind of triggered this. Before that, whether or not there was any knowledge, working awareness of the current owner-operator that there was a question to zoning, I don't know that to be true. I can't tell you, county may know, I don't know the year that the current owner took possession, whether or not someone else operated, somebody came in and bought the business and just continued to do what they've been doing for decades. I'm not going to represent that. I don't know for sure, but that certainly happens in a lot of cases where it's only when somebody brings it to your attention that says, hey, there may be a zoning issue here, that you ever even approach the county or have the county approach you. So again, we want to be good neighbors, and I do understand and respect your concerns, but that's why we're here. So.
All right, thank you. That clarified my question to that criteria. I appreciate that. Board, anything from the board? Okay. Staff?
No, sir.
Okay, at this time, the chair will now entertain a motion regarding item CU-2026-07. And with your motion, please state whether or not you adopt the staff's findings of fact as presented by staff. If for any reason you don't accept staff's findings, please go through all the criteria and address each one specifically as to why you do not concur with staff findings and provide substitute findings. Do we have a motion? Motion by Travis,
Second.
second by Ross. All in favor? Motion passes with all in favor. Our next case is case number CU-2026-11. 3001. Oh, I'm sorry. I'm sorry.
07.
Yeah, skip one.
Thank you.
And
Thank you.
I thought you said when earlier that you read CU 2026-07 was the last, but the case was 06.
Okay.
Did I not hear? I was,
Um,
maybe I misheard.
Okay. If I make a ending statement on that, would that correct that first one?
If we can just clarify on the record that the previous case, the vote pertained to what is listed as 6A, and that was case number CU 2026-06.
Okay, thank you. Okay, case number CU 2026-06. That was what the vote was for, just to clarify the record. All right, our next case is case number CU-2026-07, 1512, 1510, and 1509 Border Street, a conditional use request to allow Savage Yard, requested by Meredith Bush, agent for Angelo's Auto Parts, Inc., that's the owner. Any ex parte communications regarding this case, board? Seeing none. Any knowledge or information obtained from a site visit or other sources? Seeing none. If any, does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium and state your name and address for the record so you can be sworn in by clerk? And Ms. Bush, she does not need to be sworn in again.
Thank you. Meredith Bush, 314 South Bayland, Suite 108, Pensacola, Florida, 32502. And this is a case where I would ask that we simply adopt my prior statements. The facts are exactly the same. These are adjacent parcels. I'm happy to run through it and read through, but in order to expedite and, out of an abundance of respect for your time and everyone's time, the only reason this case was not brought in the last case is that they're two separate owners. So again, all the facts remain the same, whereas it's a long-standing, existing salvage operation. Staff has fully recommended approval. And so, for the record, I would, simply ask that we adopt my prior running through the criteria for this case, recognizing staff also agrees, and answers to your questions would be the same. It's the same exact fact pattern, just separate ownership.
Okay. Will we need a motion to adopt that?
No.
Okay, thank you. Okay, that'll be just fine. And moving forward, staff, would you like to
I would only add one thing. Similar situation with the proposed rezoning to HCLI. The one difference in this case is that the property on the west side of Border Street is under the Brownsville overlay as opposed to the Englewood overlay. The other case was completely within that. This is split by the two overlays. Same results, same recommendations.
Okay. And we have a speaker for this one. Okay. All right. Yes, sir. Go ahead.
On this one, was there any kind of reported code enforcement violations?
That's a good I would have to do some digging. Possibly on the eastern side. I'll leave that to their representative.
To my knowledge, there was not. The only code enforcement that I'm aware, at least current code enforcement, was on 1516, just one of the parcels on the other case prior to the combination. There may have been some historic.
May have been. I just can't say with any certainty at this point without looking it up. I couldn't remember which had kicked the whole thing off. There were multiple parcels and
Right.
right-of-ways.
1516 kicked it off.
Okay. Well, thank you for clarifying.
And to my knowledge, again, there are no open violations on these parcels.
Thank you.
You had a question? No, I thought you was, good. Any more questions from the board? Okay. Staff, any questions?
No, sir.
Ms. Bush, anything from you? No, sir. Okay. Yeah. At this time, since there's no further questions or anything, the chair will now entertain a motion regarding the item CU-2026-07. And with your motion, please state whether or not you adopt the staff's findings of fact as presented by staff. If for any reason you do not accept staff's findings, please go through all the criteria and address each one specifically as to why you do not concur with staff findings and provide substitute findings. Do we have a motion?
I move we accept the staff's finding and recommendation.
Motion by Ross. Do we have a second?
A second.
Second by Greg. All in favor, right hand. Motion passes. All in favor. Thank you. All right. Our next case is case number CU 2026-11, 3001 Langley Avenue, A, conditional use request to allow an educational facility, request by Richard Colbert, agent for Aerospaces Housing, LLC owner. Any ex parte communications regarding this case, board? Seeing none. Any knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. With the individual, okay, we have the individual who's a party to this item already at the podium, right?
Yes, sir.
Okay, if you would, please state your name and address for the record so you can be sworn in by the clerk.
Yes, sir. My name is Richard Colbert, 3001 Langley Avenue, Pensacola, Florida, 32504.
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Sir, were you provided with a copy of the criteria required to obtain a conditional use and a copy of the findings of facts?
Yes, sir.
All right. Do you understand that all the criteria must be met in order for the board to grant a conditional use?
I do.
Okay. Would you like to make a presentation, or would you like staff to go first and you go behind them?
I can make a brief statement just to kind of give a little background to
Yes, sir.
what I
Please
think would
do.
be helpful.
Yes, sir.
We are the owners of Carrier Landing Apartments on the parcel adjacent to the site where this proposed use is going to exist. Carrier Landing Apartments basically is occupied solely, all our tenants are flight students, either engaged or active duty with the Air Force, the Navy, the Marines, or the Coast Guard, or our civilian flight students seeking to become pilots for one or more major airlines. The other tenants in our facility are flight instructors, and basically these are the same instructors that are teaching these flight students and taking them up for flight training. We have an accessory building that we built when we built the apartments. We call it the clubhouse, but basically in that building is a dining area. We have flight simulators, which are actually kind of cool to use if you go up there and do that, that the students can use on their time to train and get ready for what they have to do. We also have some space that they will meet with their instructors, which is kind of why we're here today. We didn't necessarily view it as an educational use, but it is under the technical definition. Since they are instructing the students on occasion in the building, it has an educational use, and that's why we're here today. We really just consider this an additional accessory use for our complex. We didn't build a big enough clubhouse to start with, so we need more space. So everybody, and I want to make this very clear, that everybody that uses this space is either an existing tenant student or an existing tenant instructor. There's nobody coming to the property that's not already living at the apartment. So there's no more traffic, there's no more cars, there's no more people coming there. We just needed additional space for the existing use we already have with our students.
Okay, thank you. Staff?
Good morning. My name is Kimberly Wilson, Development Services. So I'm going to, this is they are requesting conditional use for an educational facility. So I'm going to go through the criterion and the finding of facts. What we have here is the location map of the site. Have the 500-foot radius map, zoning map. Have the future land use map of mixed-use urban. Have an aerial map showing the entire site. This is the notice of public hearing sign posted along Langley Avenue. The sign posted along the east side of Langley Avenue. And this is looking on the site from Langley Avenue, from directly on Langley. Looking on the site from Langley again. And this is just west along Langley Avenue by itself. This is across the street from the site on Langley Avenue. And this is another public hearing sign posted along Alicia Drive. It's looking east along Alicia Drive. This is looking onto the site from Alicia Drive. And this is west along Alicia Drive. This is actually looking across the site, across Alicia Drive. Okay, now I'm going to go through the criterion and the finding of facts. Again, they are requesting an educational facility, conditional use for an educational facility. I'm going to start with criterion A, general compatibility. The finding of facts, the proposed use as requested by the owner applicant is an educational facility intended to serve the existing residents or flight students residing at the Carrier Landing Apartments. Proposed use appears capable of being conducted and operated in a manner compatible with the adjacent properties and overall character of the surrounding area. The applicant has submitted a site plan illustrating the proposed 2,677 square foot facility, along with a silt survey identifying the location of the proposed structure. B, facilities and services. Public facilities and services are available to serve the subject parcel and are currently being utilized by the applicant for the existing development, which is Carrier Landing Apartments. C, on-site circulation, ingress, egress. The property is located on the south side of Langley Avenue. The site will utilize the existing parking lot and driveway, which currently serves Carrier Landing Apartments, that development. The parking within the right-of-way is prohibited, so you can't have any parking on the right-of-way at all. All parking associated with the proposed use shall occur within proposed parking spaces located within the Carrier Landing complex that already exists. The proposed structure is not anticipated to adversely impact traffic circulation or pedestrian safety or emergency vehicle access, and it appears it should be consistent with the functional use of the roadway. D, nuisances and hazards. The applicant has stated that the proposed use will not produce unreasonable noise, glare, dust, smoke, odor, vibration, electrical interference, or other nuisances or hazards affecting adjacent or nearby properties, as all activities will take place indoors of the facility. E, solid waste. Based on the submitted application, the proposed facility will not adversely impact the solid waste collection services currently being provided to the parcel by ECUA Emerald Coast Utilities Authority. Screening and buffering. F. Based on the applicant's submitted plans, a 6-foot wood privacy fence will be installed along the northern and eastern property lines, meeting the screening and buffering requirements of our Escambia County Land Development Code. G, signs and lighting. Applicant has stated that all exterior lighting will be attached to the proposed building and will be designed and directed to avoid glare and impacts on traffic safety. The lighting will be operated in a manner that does not create a nuisance for neighboring properties. H, site characteristics. Based on the survey and the site plan submitted by the applicant, the site can accommodate the proposed building. If conditional use is granted, the applicant will be required to submit construction plans to comply with all the applicable standards outlined in the Land Development Code and the Florida Building Code. Additionally, any other site characteristic reviews, setbacks, those items will be addressed during the land use approval process, the site plan review process. Use requirements. The proposed use will comply with the additional conditional use requirements of the zoning district and other provisions of the Land Development Code as outlined in Section 3-2.9 C4F Educational Facility. If conditional use is approved, approval is granted, the applicant will be required to submit plans that meet all applicable construction standards in the LDC Land Development Code and the Florida Building Code again. In conclusion, staff findings based on the review of the submitted material and the applicable Land Development Code standards for an educational facility, they have been met. Therefore, staff recommends approval of the requested conditional use. If approved, again, the applicant remains responsible for obtaining all required permits and completing any additional reviews necessary prior to construction of this location, at this location.
Thank you.
If I may, just, if you could show the aerial again?
Sure.
Just,
Yes, sir.
I just want to point out where the building is.
Yes, sir.
It's not
That's
really
fine.
clear in the
Yes, sir.
location, I don't think. Just right there, that little area, the wooded area right next to the swimming pool, basically it's got apartments on this side. The north is the State Farm Insurance Office. They sold us that little piece of land, so they're very happy with what we're doing. And on the other side is the city soccer fields and park there. So
Okay.
I don't think we have any impact. The only impact really is the noise of all the soccer kids, which actually I kind of like. It's kind of fun to hear them.
All right, thank you.
Any questions?
Any questions from the board? All right, we have one speaker, and we have one that that is in favor, that wishes not to speak. And Ms. Linda Williams, will you approach the podium? State your name and address and get sworn in by the clerk.
Sure. My name is Linda Williams. I live at 6150 Alicia Drive, Pensacola, Florida, 32504.
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay, since I live directly down from this complex, I wanted to know what was being built, because after driving through the property, at the time, I was not aware that they had purchased additional property, because there's not 1 square inch on that property to build anything else. So, coming to this, I realize now that they've purchased additional property of where it will be built. So, I guess my answers, the questions that I had, although I do have a question. Originally, when this project was going to be built, there was sworn testimony that it was going to, the people that would be living there, that first of all, they were apartments, and they're not. They're 4 bedrooms connected with the kitchen, so they're basically dorms. But we were told there were going to be all officers living there, and that they had contracts with the Navy and contracts for this whole flight school with some helicopter company, none of which turned out to be true. So is everyone living there a naval aviator, which is constantly being stated at these meetings? Or can anyone live there?
That's not, respectfully, that's not something that we're here for today.
But it's something that's talked about for approval for all conditional use permits involving this property.
What,
So the county doesn't regulate who property can be rented to? And apartments are a matter of how the transaction is set up. It's not a dormitory, it's an apartment. Some things aren't always traditional as far as number of units within, but it still meets the definition for an apartment. And we don't regulate who can be rented to.
But if you're stating that you only allow certain residents, and that's not true.
So
You're basing your conditional use on those facts. Don't you think that's pertinent to this issue?
conditional use is based on the 9 criteria, one of which isn't who their civil relationships are worked out with.
Okay. And flight simulators, to my knowledge, dealing with a lot of aviators and knowing a lot of people who've been through all this process, cost approximately $6 to $8 million. They have actual flight simulators, $6 to $8 million flight simulators they're going to have on the property.
Again, educational facility doesn't regulate what goes on within the building. We're talking about that use of the building, not the specifics of it.
So you can just come in here and say anything you want, and then it's okay.
So all testimony is given under oath. They are saying what they're saying. Conditional use runs with the use of the land, so that's something to keep in mind.
Okay. Well, we'll be keeping an eye on the project.
Absolutely.
Thank you.
All right. Does the board have any questions for Ms. Linda? No questions? Staff, any more comments or anything from the owner? Okay. At this time, the chair will now entertain a motion regarding item CU 2026-11. And with your motion, please state whether or not you adopt the staff findings of fact as presented by staff. If for any reason you do not accept staff's findings, please go through all the criteria and address each one specifically as to why you do not concur with staff findings and provide substitute findings. Do we have a motion?
I make a motion that we accept staff's findings and approve the request.
We have a motion by Greg. Second. Do we have a second? We have a second. All in favor, raise your right hand. Motion passes. All in favor. All right, our last case for today, case number CU-2026-12, 8700 block, Beulah Road, a conditional use request to allow a drive-through within 200 feet of LDR zoning, requested by James Hughes, agent for Aqua Ventures Properties, LLC. That's the owner. Any ex parte communications regarding this case, board? Seeing none, knowledge or information obtained from a site visit or any other source? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Okay, we have the individual who's a party to this item at the podium. Please state your name and address for the record so you can be sworn in by clerk, sir.
James Hughes, 412 South Broad Street, Mobile, Alabama.
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did.
Were you provided with a copy of the criteria required to obtain conditional use and a copy of the findings of fact, sir?
Yes, sir.
Do you understand that all the criteria must be met in order for the board to grant a conditional use?
Yes, sir.
All right, thank you. Sir, would you like to make a presentation first or hear from staff and then?
I'll hear from staff and then take any comments.
Yes, sir. Staff?
Development Services. We're going to start with the, I'm sorry, this is conditional use 202612. Location map, 500-foot radius zoning map, the future land use map of mixed-use suburban, I'm sorry, aerial map, excuse me, notice of public hearing sign, looking northwest onto the site, looking south along Beulah Road. This is east across Beulah Road from the site. And now we're going to get into the request of conditional use along with the criteria. So they are requesting to allow for a parcel boundary of a restaurant or brew pub with a drive-through or drive-through services less than 200 feet from an LDR or MDR, medium density residential or low density residential zoning district. And conditional use, of course, it's for, this one is for residential services, restaurants, not among the permitted uses of the district. So starting with criterion A, general compatibility. The proposed use is compatible with the adjacent properties and the character of the surrounding area, while the site abuts LDR, low-density residential, and MDR, medium-density residential zoning districts. The applicant has stated that the development would be located as far from these districts as practical in order to minimize potential impacts on the surrounding residential area. B, facilities and services. Public facilities and services will be confirmed through review by Emerald Coast Utilities Authority, and if approved, will be utilized by the applicant for the proposed development. C, on-site circulation, ingress, egress. The subject property is located along Beulah Road. All ingress and egress will be required to comply with the standards of the Land Development Code and will be evaluated during the site plan review process to ensure that all applicable requirements are met prior to approval, such that the proposed development will not adversely affect traffic circulation, pedestrian safety, or emergency vehicle access, and will be consistent with the functional use of the roadway. D, nuisance and hazards. In accordance with the requirements of the Land Development Code, the proposed development, which is adjacent to residential uses, will be subject to site plan review to ensure that it does not produce unreasonable noise, glare, dust, smoke, odor, vibration, any type of electrical interference, other nuisances or hazards affecting adjacent or nearby properties. The ordering kiosk and speaker will need to be oriented away from the residences to the extent possible. I don't know if Mr. Homer wanted to chime in on that. I think that's what you.
That correct. That's just a general condition that comes up anytime we have drive-throughs near residential uses. No one wants that to hear the squawk box in the middle of the night. So the site plan that was submitted there's going to need to be some adjustments made to that regarding turn radiuses and the location of those speakers relative to the residential uses. And something else for the board to keep in mind, we do deal with sign variances from time to time. As uses change, sometimes the signage required changes. We've been seeing more and more situations where drive-throughs have multiple lanes and multiple ordering kiosks. Our code wasn't written anticipating multiple ordering locations, and the signage there, that's something we're going to have to address going forward.
Thank you, Mr. Homer. E, solid waste. Based on the information provided by the applicant, the proposed facility is not expected to adversely impact solid waste collection services for the property, which will be reviewed and provided by ECUA, Emerald Coast Utilities Authority. F, screening and buffering. In accordance with the Escambia County Land Development Code, the applicant is required to comply with all applicable screening and buffering requirements. Compliance will be evaluated during the site plan review process. Per Section 2-2.3 of the Land Development Code, Escambia County Land Development Code, Design Standards Manual, the applicant will be responsible for constructing a 16-foot vegetative buffer along the property lines that abut those single-family residential uses. Compliance with the screen and buffering requirement will be confirmed during the site review process. Criterion G, signs and lighting. The applicant has stated that all exterior lighting will comply with the Escambia County Land Development Code and will be designed and directed to minimize glare and impacts to traffic safety. Therefore, the proposed lighting will be operated in a manner that does not create a nuisance for neighboring properties. Criterion H, site characteristics. In accordance with the requirements of the Land Development Code and Florida Building Code, the applicant must meet all applicable development and construction standards to accommodate the proposed building. Compliance with these standards, including the site characteristics such as setbacks, things of that nature, they'll be evaluated during the site plan review process and the planning land use approval process. I, use requirements. The proposed use will comply with the additional conditional use requirements of the zoning district and other provisions of the Land Development Code as outlined in Section 3-2.10, C3A for restaurants. If conditional use approval is granted, the applicant will be required to submit plans that meet all applicable construction standards in the Land Development Code and the Florida Building Code. In conclusion, the staff findings, based on the review of the submitted material, the proposed restaurant with a drive-through meets the applicable standards of the Escambia County Land Development Code. Therefore, staff recommends approval of the requested conditional use. If approved, the applicant shall remain responsible for obtaining all required permits and completing any additional reviews prior to construction to this location. And that concludes our staff findings.
Thank you. Any questions from the board? I have a question for staff, just concerning the ordering, like the drive-through intercom system. Are there any kind of way? Is there any kind of way, like when these restaurants start moving closer to the subdivisions? Is there any kind of way for like a sound wall or something, or does that vegetation kind of cut the noise down, level down?
So again, that's the reason these are conditional use is so that they come before this board for review like that. That is certainly within your purview to recommend something of that nature.
Because my concern is that neighborhood. It's a neighborhood right next to that property.
Right.
It's pretty close. It's easy and close. Because there's a McDonald's on the corner, but that, their intercom system is close to the road, and I doubt they can hear that. But easing closer to that subdivision, I feel like there should be some type of sound wall or something to protect them for the noise. Step to the mic, that way it could be on record. Yes, sir. You go ahead.
Purposely moved the potential QSRs closer to the Tom Thumb to the north area to be furthest away from the residential neighborhood. And then we have proposed to put, as our esteemed colleague here says, squat boxes furthest to the north, facing that Tom Thumb. So we are trying to limit, that noise, where that noise is going to the north and not to the west, per se. And we agreed to do all screening, fencing, and everything else that is going to, prohibit that sound from being able to transfer to those neighbors, including parking lot lights to be also in the back facing down and not facing out, where there would be any potential glare into the back of those residences as well.
How many feet of that vegetation is going to stay back there towards those houses on the northwest corner?
Well, I developed and built the storage facility, Anytime Storage, on the opposite side of 9 Mile. And because of the tree ordinances that the county has, I ended up saving basically the 10-foot buffer that was recommended that I take out. I left lots of trees. You're going to probably see on the plan that the engineer states to clear that out and plant trees back, but it's in my opinion that I want to keep those trees. I have no desire. If they're not in the circulation of the building, and it's within that 10 to 15 foot right of way, I plan on keeping every piece of vegetation that I can. If they require that I come back and plant more, I'm completely amenable to being able to do that.
And they are required to have a minimum of a 16-foot vegetative buffer there.
Okay.
So at the minimum, 16 feet. If you feel like it needs to be more, that's, within
So in
your rights
addition to the trees that we keep within that buffer and then add to, we're agreeable to keep that from not becoming a nuisance to those neighbors.
Okay. Any questions, board? Okay, if no further questions, the chair will now entertain a motion regarding item CU-2026-12. And with your motion, please state whether or not you adopt the staff findings of fact as presented by staff. If for any reason you do not accept staff's findings, please go through all the criteria and address each one specifically as to why you do not concur with staff findings and provide substitute findings. Do we have a motion?
I move we accept staff's findings and recommendation.
Motion by Ross. Do we have a second?
No, second.
Second by Greg. All in favor, right hand. Motion passes. All in favor. Thank you.
Thank you, Stan. Enjoy the rest of your day.
I'll just say at our next meeting at April 15th, I already have at least 2 cases. So we will have a meeting next month.
No, sir.
That's everything.